A request that I know that Honorable Mabena, if we can separate your issue because you said it's not related to Luxembourg protocol, we'll come back to it. Let's finalize and close this one neatly. Is that no? I'm saying let's complete this one first, but it's related to the Luxembourg protocol. Oh, okay.
No, thanks very much, Chair. I didn't want to interrupt the minister. I think it would not have been good to do so. But just on the on the issue of Article 9 that was raised, that South Africa has adopted, I think it's subsection C. The remedies in terms of the court process, here's the challenge with that, Chair. And I think 60 seconds, I think you can time me, I'll be done. The Swifambo rail deal was the contract was issued in 2013. But before I go there, let me start here. I think it's Mr. Can I give Mr. Ma? Mr. Makaipia. He said when he was responding to me that the risks are that needs to be addressed is that better protection of creditors, ensuring that we preserve the international image of South Africa, but also our ability to raise more funds in the international markets is key. Now, we say the court process. The deal was signed, the Swifambo deal was signed in 2013, was nullified by the Supreme Court of Appeal in 2018. 2018 is signed, 2018 is nullified. Till today, it has not been resolved, and it's through the court process. It's still in court as we speak today. So, meaning that 2018, 19, 20, 21, 22, 23, it's going to be over 6 years now. What happens? What is the alternative for the court process in the event? Because we've selected Article 9, and the main reason is because of the court process. But what happens within the 6 years to the one? Our ability to protect the creditors, ability to raise more funds in the international markets while this issue is being resolved. Because if the Luxembourg protocol was in place then, when this Swifambo deal was happening, then that means in the 6 years and ongoing, meaning that creditors would be wary to give us more funds because they would say South Africa uses as a remedial action the court process, and the domestic court process in South Africa, the litigation is quite lengthy. What then happens? Because someone says 3.5 billion rand is tied into the deal.
You requested me to time you.
Yeah, oh yes.
Exactly that.
Thanks.
No, I think what Honorable Mabena is saying, Minister, is that go home and do a homework based on the lessons, the current existing lessons that also delay some of the issues to be finalized, because the exam that is making, based on what she has read, and there's evidence that it says that the turnaround thereof, it's outside our control, and also then it lessens the appetite of investors. And I think probably if we do that, it will be better than also responding in terms of the prawns and details of Swifambo case study, as it were. Voice. Voice. I want to hear the voice. The voice, Minister. I want to hear your voice, not your head.
Agreed, Chair.
Yes. Because all what you are saying is that there are lessons that we can borrow for, so that we can do better moving forward, because at least we still have got a chance to do that. With that, honorable members,
Oh. I only want to say something. Am I correct? Contract between China and South Africa between us for manufacturing and spare parts.
is that Luxembourg agreement protocol?
Chair, it's a matter between DPE. As a matter of fact, it would have been better responded to by DPE. But there is the issue which is about intellectual property.
Oh, yes.
If we want to manufacture the China parts, then we'll need to get the permission from them, because of them owning that intellectual property. Yes. Thank you.
Yeah. Hence, ours is going to be patent as well, so that you can track it as well. No, with that, we are getting smarter every day. With that, honorable members, here is the protocol, and these are the subheadings. What's this now? The protocol itself, yes, but there's what they've spoken to, isn't it? Oh, yes, the one that Honorable Mapena also make reference to. No, thank you very much, Advocate. Now, honorable members, we've engaged, and we've got the details, and also we've engaged in terms of what it means and its implications in the laws that governs us as a country. If you can just flight the recommendation. Advocate, thank you. I also was strong, Tom. So the report will be like this, and we're just waiting for the bling bling to come up. What happened? It has been working when you were here. Okay.
But Chair, on a serious note, when I was sitting there, the advocate never sat on the floor, ever.
It's how relaxing she is. To save time, let me just allow Honorable Mabena to raise the point, because I thought we just wanted to be clean. Can we park this while advocate is dealing with technology? Then Honorable Mabena, your point, which is not related. Yeah.
Thank you very much, generous, honorable chairperson. Yeah, Chair, I think we just to take advantage of the leadership of the department and the political principles. I think we dealt with the ATNS BRRR. I was unfortunately sick and I was not here. But there was an issue in terms of, if you read the financial statements, and there was 355,000 rands which was written off. So there was money which was overpaid to directors of the board, Mr. Padat and Mr. Mieza. Mr. Mieza was overpaid by 142,000, and then Mr. Padat was overpaid by 212,000, and they refused to pay back the money. So and it was not only the two of them. There were others which were overpaid, and the others paid back the money. But these two refused to pay back the money. But what is of concern is the following. One, that ATNS went ahead and wrote off that refusal to pay back the money from their balance sheet. So they wrote off that thing, and they just simply agreed for those two not to pay back the money. 355,000 rands of taxpayers' money down the drain, and that was written off by ATNS, and it's contained in the financial report. If you read in terms of the credit loss and allowance, item number 6 on the financial report, it says, due to an incorrect VAT interpretation, management made an error and overpaid the directors in the previous periods to 31 March 2021. And then it says you must see note 35. If you go down on the financial statement, you go to note 35, then it's contained. It says, for the full amount of overpayments, the following directors raised affordability concerns. And I'll also raise another issue with that affordability concerns, and advise management that they could not settle the full amount. As such, the respective debt had to be impaired, meaning that money had to be written off. But then again, if you come back during the year under review, management wrote off a debt of 350.
Honorable Mapena, you know what? I never envisaged that you would be going to what we have dealt with, covering that you are not present. With due respect, is quite a very fundamental, important one in terms of good governance and financial management, as it were. That you raise it and complete your presentation, and I'll request the department that they do it in writing, because I don't want us to conflict the processes, as it were. You can't have concluded it, and because we will be setting a very wrong precedence that will never ever be able to contain. I will suggest we do that, but also the department does it in writing, so that by the time then we finalize our report, our our report, then it also incorporate the points that we would have raised. And of course, we are raising a very important one, that here it up is like one jacket doesn't fit all, in terms of paying back what is due, which was unfairly paid to the individuals. You may proceed, though.
Thanks, Chair. I think I'll take your guidance in terms of that, and I'll fully confine myself to exactly what you said, and I agree fully with what you're saying. But just to conclude, Chair, in terms of the same financial statements, if you read again, it says that during the year under review, management wrote off 355,000 rands relating to the director's fees, which relates to prior years. This has been included in the 2022 financial year as fruitless and wasteful expenditure. So ATNS writes off the debt as wasteful and fruitless expenditure. The two are then let off, and then they don't pay back the money. But of particular concern here is the other issue. In November 2022, the minister back then was still the deputy minister, and the minister was Minister Philip Mbalula. They were at the AGM for ATNS, and then they knew about this. And then the term of the two directors came to an end in January of this year. But even then, this issue was not resolved when the minister was still the deputy minister. And now, again, the minister is now being promoted as a minister, and this issue again, and it's there in the financial report. And this report, Chair, my concern is that it's a matter of public record. You can access it. Any member of the public can access it. But also, if any member of the public can access it, they say that as the Portfolio Committee of Transport, we dealt with the BRRR, and that is a dereliction of duty on us to say, why are we not querying this thing? Why is it that this issue is just allowed, that someone is overpaid taxpayers' money, and then when the issue is raised, the two simply refuse to pay back the money? And that is debt that is written off, taxpayers' money, 355,000 rands down the drain, and nothing is done about it. We're moving on as business as usual. And I think, Chair, I'll confine myself to what you have said, but this issue dates back quite, as I've already said, at the AGM in November 2022. And it's something that the department, and because as the department for the ATNS, they must address, and I think they should address it in writing, as you have correctly said, Chair. Thank you very much. And I think the convention within the committee is that the turnaround time is 7 working days, if I'm not mistaken, but I can be corrected. Thank you very much.
No, on that one, you are on point. You know, Honorable Mabena, Advocate Nell and Ms. Valerie will agree with me, or will confirm what I'm going to say, that one of the issues that I raised with the AG, that we wouldn't like, especially now moving towards the end of our term, whereby we'll make recommendations for the sake of making recommendations. What more powers do we have as the portfolio committee to employ if then we are not listened to, especially in terms of where monies are involved? And the response of the AG was that you approve the business plans, you approve the budget, but of course you have not exercised your right of disapproving. I know that one of the committees that I'm not going to make a reference on, they did in the way that also makes the department, that particular department, not to pay, be able to, in a position to pay salaries. But I think even ourselves, to assist the minister, there is something that we can do on that, because the way you are putting it, I fail to understand if all of us here as members get overpaid, and 3 of us we pay back, and 3 of us here doesn't pay back, but on the similar conditions, what is that? But probably the minister, because we are not opening the issue, and I think it will be in writing, but it will be fair, because also it's being at that when in her immediate appearance here, she can use that opportunity to take us through so that the South African also can be listened to. But I'm saying then, when we're doing the recommendations, honorable members, we must also cross-check in our previous recommendations so that we don't repeat them. We just leave them as that, and then we see how do we craft it in the way that it empowers the incoming administration in terms of giving power, because sometimes we're judged to say that we're not doing the expected oversight, as it were, because sometimes we limit ourselves on some of the issues and say, no, we'll put it on the recommendation, on observations and all that. But the engagement that I had, Minister, it was very empowering, because I know that, and others will say that, but some of you are in the majority leading party in government, but officials are officials, entities are entities, and also they must know that if they don't perform, also it refers to your good self, Minister, and DM in particular. Other than that, I'm sure you'll agree with me that you will respond in writing, because we still have to check with them in terms of the details, although it's in a public space. But when we come back, also in engaging with your good self, also we'll talk to it. But let me not suppress you.
No, thank you very much, Chairperson. We will indeed respond in writing to give details. But safe to say that this matter, we got to know about it during the
AGM.
reporting of the 2022 AGM. And we raised it with ATNS clearly that people who were overpaid must pay back all the money. At that AGM, ATNS did indicate that there were non-executive directors who had indicated that they will not be able, they won't afford to pay back the money. And we're very clear to say they will still have to pay back all the money. Also, there were some, particularly the chairperson, who seemed to be saying it wasn't their mistake and therefore they will not want to pay. And we said they will still have to pay back the money. And we were informed by ATNS that non-executive directors had actually made arrangements to pay the money. So it was not like they're going to pay, if you owe 200,000, you're going to pay 200,000, because we could understand that they may not have that lump sum. So there was the issue that they are actually arranging to make payments. During this AGM, we asked again the same question. And ATNS informed us that yes, members, the executive members are paying back the money. Again, we're very clear to say all of them, we can't have people who are paid, who are overpaid, and for any reason, then they say they can't pay back the money. And that is what we are actually monitoring. I just want to say that. It is not our position, at least it's not my position as the shareholder, to say there will be people, for whatever reasons, who will not pay back this money. That is very clear to ATNS, that whether people say they can't afford it, they were overpaid and they've got to pay back their money, whether they're still part of the board or they are not part of the board. We did ask the question even during this AGM as to whether those that are no longer members of the board, are they able to trace them? They say yes. They said yes, and they will make them to pay back. Whatever that is in the report, as far as we are concerned, all non-executive board members will have to pay back the money that they were overpaid with, and that is our position on this matter. Just want to clarify that point. That is our position on this one matter. However, it is not our expectation that if somebody owes 50,000 rand today, then they will have 50,000 rand to pay. They will pay in terms of the arrangements that they have made with ATNS. But they will pay, we expect them to pay even the cent of that. They can't write off that money. Thank you.
So you have given us a verbal response, honorable ministers. Can we then visit their financials in terms of the write-off that Honorable Mabena is referring to, and ensure that when you do it in writing, then it does, so that also we are at comfort. And it's not that we are doubting you, but the writing off and non-writing off and what is supposed to be done, and I think it should be like that. Then we'll deal with it when we meet in our report preparations and all that. But let's thank Honorable Mabena to raise it, so that also we are given a space on behalf of, or as a shareholder to respond and give clarity on that, which across the board it happens that way. With that, honorable members, let's go back, then get to the report, and now the Panya is there. But we're going to read it to say that today, with the report of the Portfolio Committee on Transport on Luxembourg Protocol to the Convention on International Interest in Mobile Equipment on matters specific to railway, rolling stock of 23 February 2007, dated 17 October 2023, which is today. The Portfolio Committee, then that's an essence of the recommendation. The Portfolio Committee of Transport, having received a briefing on 17 October 2023, and having considered the request for approval by Parliament of Luxembourg Protocol to the Convention on International Interests in Mobile Equipment of matters specific to railway, rolling stock of 23 February 2007, referred to, recommends that the House, in terms of Section 231 of 2 of the Constitution of the Republic 1996, approve the said convention. The report, honorable members, is tabled for us for consideration to be recommended for the House to consider it. May we get the mover and the seconder? Honorable Ramadwa.
Thank you, Honorable Chairperson. I move for the adoption of the report. Thank you.
Thank you very much. Honorable Makumal.
Thank you, Chairperson. I second.
Thank you very much, honorable members. The protocol is hereby approved by the committee, then it will be processed accordingly. Thank you very much. And thank you very much, Honorable Minister, and I'm sure we didn't inconvenience you in terms of your data of the day. Then, honorable members, it will bring us now to item number 2. In terms of our agenda, I'm waiting for my dashboard. I think it's who's our? It's you. Hi. I will hand over to your good self, to your good self, to take us through on the marine oil pollution bill. Just to recap, the Will Connect, honorable members, that last week we dealt with it, and in terms of clause by clause, but there were issues that today we'll deal with the A list. But the back office work that was supposed to be done by Mr. Ntuli from the department and also our state law advisor was to, one, one was to cross-reference and share notes and also have a discussion and common understanding in terms of the posture of the department when they say that they note, they agree, they don't agree, in terms of the submissions that would have made by it's ask what's that NGO, maritime NGO for penguins, what was it? Suncorp. By Suncorp, as well as the provincial government of the Western Cape. And of course, when we're dealing with it last week, we're not necessarily looking at that, but also there were comments whereby the department made, and I would then, DDG, Mr. Ntuli today, I don't see him. There is he right at the back. If you can come somewhere here so that I can see you as well. Mr. Ntuli, if you may, before our state law advisor take us through, confirm that yes, indeed, you had those bilaterals with the state advisor, and we are ready to go today. If there are any issues that still need to be ironed, noting that the bill now is before Parliament. It's our process. Okay, you may proceed, Mr. Ntuli.
Good day, Chair, and the members of the committee. Thank you very much for the opportunity. I wish to just state that yes, indeed, as instructed by the committee, and on invitation of offer from the state law advisors for us to come together and consider the outstanding matters that indeed we met yesterday.
Yes.
We met yesterday to conclude, and what's going to be presented now by Mr. Tetiane would represent the collective view which we are now putting forward to the committee. And if there are any matters of needing clarity, we would be available to do that. Thank you very much.
Thank you very much, Ntate Ntuli. May I then give it to you, Advocate Tetiana, to take us through, and we'll take up from there.
Good afternoon, Chairperson and honorable members, and good afternoon to my colleagues as well. Just to confirm what Mr. Ntuli has said, it's true, Chairperson, that we met yesterday. You will recall that there were about 8 or 7 issues I had characterized as sticky issues, but we were pleased to report back that there's been a breakthrough. So Chairperson, let's cut to the chase. You will see that our report back to you encompasses 7 clauses, and of course we'll start with clause number 5. Chair, for ease of reference, what we've also done is that, because we won't be discussing the entire draft A list, we'll just zoom in on the highlighted ones. All right. So, Chair, on point number 3, on clause 5, Chair, on page 5 from line 44, what we've done there is that we were omitting the following words: that alters the risk of marine oil pollution incidents in a port.
Sorry,
Okay.
Advocate, I was just consulting with
All right.
my learned advocate this side as well.
Okay.
To say honorable members will take the same process, will embark on the same process, that he will talk to the clause and the sub-clauses thereof, and then I will also then wait for the response to members to adopt. She will only speak to those ones that had some issues to be ironed up, not
Yes.
everything.
Yes.
And then after that, then it will go for being cleaned, and then it will come back for us for approval. So I just wanted to say, how do we going to walk this road? We're not going to repeat everything.
Yes.
Honorable Ramatwa, I guess you want to say
Chairperson, we agree on your proposal.
Okay, you may proceed, Advocate. Thank you.
Thanks, Chairperson. Chairperson, on page 5 from line 44, you will see that we've made an omission there. We've omitted some words, and the reason is simple, Chair, is that what we're omitting is already defined as new development. So we're omitting the words that alters the risk of marine oil pollution incidents in a port facility, oil handling facility, or offshore installation, whichever comes first. And the reason that we're doing that, Chair, is because new development has already been defined. And then on page, Chair. Yes, on page 5, Chair, from line 47, we omit the words, the risk assessments undertaken under subsection 1 must be reported to the Director General, and we substitute that, Chair, with a very specific heading where we say the risk assessment undertaken under subsection 1 must be reported by the authority to the Director General. And then, Chair, on page 6, from line 1, Chair, there we're only omitting and lodged oil and gas exploration extraction. And if I may read it, the entire sentence for you, Chair, it will now read: the locations and describe marine oil pollution risk, including spatial zone of influence of a potential pollution event for all present installations or decommissioning applications for such. So that's how it will read now, Chair. And then on page 6, Chair, from line 19, we omit the Director General must, within 2 years after this act comes into operation, cause that the marine pollution risk assessments be undertaken by the owner and operator of any port facility, oil handling facility, or offshore installation at its costs. And we substitute that, Chair, by the owner or operator of any port facility, oil handling facility, or offshore installation must, at its cost, after 2 years of the commencement of this act, undertake the marine oil pollution risk assessment. And then, Chair, on page 6, from line 26, we do the same thing, Chair, because of the fact that the term new development has been defined. We omit that alters the risk of marine oil pollution incidents in a port facility, oil handling facility, or offshore installation, whichever comes first, that being the definition of new development. And then on page 6, Chair, in line 34, after finalized, we insert a comma with the proviso that this section does not apply in cases of activities with no contact with the environment. So that's the proviso we're adding, Chair, which says that this section does not apply in cases of activities with no contact with the environment. And Chair, that concludes clause 5.
Honorary members, on this one, let's park it because we need 6 members in the room. I'll wait for Honorable Mapena to come back. Then I'll call it.
Thanks, Chairperson. And then, Chairperson, we proceed to clause 9. And at clause 9, Chair, on page 8, from line 25, to omit "and" after "develop," and to insert a comma after "develop," to insert "and fund" after "implement," and to insert "mandatory" after "program of," and to insert "and non-governmental organizations" after "organs of state." Now I'm going to read it, Chair. How is it going to read? Now, 9.1, Chair, will now read as follows. The authority, together with the incident management organization, must develop, comma, implement and fund an annual program of mandatory training and exercises in marine oil pollution control and cleanup for relevant officials from all organs of state and non-governmental organizations that are members of the IMO, and the outcomes of such training and exercises must be used to update and improve the NOSCP and related arrangements. And that concludes, Chair, the amendments we've effected in clause 9. And now we proceed, Chair, to clause number 11. You will recall, Chair, that there was an issue raised by the Western Cape government regarding the fact that who is this senior technical appointee, and I think that's what this amendment addresses. On page 9, in line 21, to omit his or her senior technical appointee and to substitute relevant Deputy Director General or Chief Director. That concludes our amendments, Chair, in clause 11. Entry of permission, we proceed to clause 14.
Permission granted.
Okay, thanks, Chair. Chair, you will recall that, again, one of the issues that was raised by the Western Cape government was the issue of the oil spills. How do you define or characterize a small oil spill, medium oil spill, large oil spill? And these changes, Chair, that we have done respond to the concerns that were raised by the Western Cape government. On page 11, Chair, in line 3, we omit small spills that are within the national, and we substitute that by up to 1 ton oil spill that are within the local. So in other words, Chair, a small spill now is up to 1 ton. A small oil spill is up to 1 ton. And then on page 11 in line 8, we omit medium spills and we substitute oil spills from 1 ton to 10 tons. And then on page 11 in line 13, we omit large and substitute transporter. So this would be a transporter spill, oil spill. And through your permission, Chair, we can go to clause 15. Thanks, Chair. Okay. Clause 15, Chair, on page 11 in line 29. We omit during to substitute subject to clause 14.2a. So we say subject to clause 14.2a, comma, and we say during, because that was one of the proposals of the Western Cape government.
If you recall, last week we didn't have any proposal, you remember. Now this is a new proposal. What informs it?
I think it's one of the issues, Chair, that I had flagged. Remember, at the end, you had allowed me to say, do I have anything to say? Okay. And I said there were 9 issues, which some of them were raised by the Western Cape government, which I felt that the department didn't deal with them. So this was one of the issues.
It's those issues that you would have ironed.
Correct, Chairperson. Correct, Chairperson.
Okay, proceed.
Okay. Oh, clause 16, yes, clause 16. On page 12, Chair, from line 3, after the word relevant, we insert and appropriate. And after bodies, we omit and appropriate, so that it reads well, Chair. Yeah. Through your permission, Chair, can we go to, I think it will be the last clause now, Chair, clause 31. And you will recall, Chair, there that the issue was cross-referencing. 31. On page 18, Chair, in line 24, to omit clause 5 subsection 3, clause 5 subsection 4, clause 5 subsection 7c, clause 5 subsection 7e, clause 5 subsection 9, clause 6 subsection 1, clause 7 subsection 2, clause 7 subsection 3, clause 7 subsection 4, and to substitute clause 5 subsection 4, clause 5 subsection 9c, clause 5 subsection 9e, clause 6 subsection 1, clause 7 subsection 3. And that concludes our business from our side for the day. Thank you, Chairperson.
No, thank you very much. Honourable members, we are less than 6 here. That will suggest that Honourable Ramad.
Thank you, Honorable Chairperson. The other member is still in the bathroom. He's coming. So that we must be 6.
Okay. Probably, Advocate, if you may just talk to the guidelines on clause 14 and just go back to them. The guidelines. Yes, please, if we may. Allow Advocate Tijana to proceed. Thank you. No, but I've just called the advocate to. Ndithetha nodwa ngoku. Cofa.
Page 10, page 11. Plus. Take this out. Yes, Chairperson. Chairperson, you will recall that when we were presenting here last week, I think the members, and I apologize for that, Chair, the members had said that the word guidelines should be part of this. So I'm taking that out, Chair.
Okay, so yes, okay. Yeah, probably just for completeness, just read the whole clause. Yeah. Ubusuyacofa futhi. Okay.
It's 14 subsection 1, Chair, line 41, page 10, line 49, I'm sorry, Chair. At the bottom of the page, under the heading Initial Response Actions. Whenever the authority receives a report of a marine oil pollution incident, it must initiate a response in accordance with the NOSCP guidelines. And the first actions of the authority must be to report to the incident manager appointed as such by the minister under section 10.3 and directed by him or her. So what happened, Chair, is that you will recall that I think the Western Cape government had said there's no need for us to retain that guidelines there for the simple reason that it's not defined. But I think the members said no, for the sake of readability and so on. Because from our side, Chair, we said even in terms of content, and we're not opposing anything to it. So the members requested that we leave the word guidelines. Yes. Thanks, Chair.
Okay, no, thank you very much. Just for completeness of what we are going to be doing, last week we were going clause by clause as we have an agreement on those clauses, we approve them, we agreed to them. Let me use that word, which means we are not going back to them. May I now, for today's purpose, I will read all the clauses, and I would like members to write them down so that when members respond, they respond in terms of the clauses, all in terms of numbers for the completeness. It's clause 5, clause 6, clause 9, clause 11, clause 14, clause 15, clause 16, and its sub-clauses as presented and read by the state law advisor. Is that agreed to, honorable members? We'll need a show of hand for that, like last week. Honorable Ramato.
Thank you, Honorable.
Kofa.
I move that, thank you very much, Honorable Chairperson. I move that we adopt clause 5, clause 6, clause 9, clause 11, clause 14, clause 15, clause 16, and sub-clauses as presented.
Okay, thank you very much, Honorable Ramato. Any seconder? Honorable Kumalo.
Thank you, Chairperson. I do second clauses as made mentioned by my colleagues.
Thank you very much. Now I put before you clause 31, which deals with the cross-referencing. Any support in terms of that, which is more of a back office administrative work? Honorable Ramato.
Honorable Chairperson, thank you. I move for adoption of clause 31.
Okay. Any seconder? Honorable Mamtungwa.
Thank you, Chairperson. I second the adoption of clause 31.
Thank you very much. Honorable members, for the purpose of to allow the back office work, allow me to put before you the bill as presented for adoption for the purpose of allowing the cleaning up of the process. And if there are commas or dot or is which lacked I and it's only S, should come back to the committee for adoption. But as presented now, this is what will go to, what do you call that? CRIDA. To CRIDA for legal administrative back office work in terms of cleaning up, then it becomes a complete A list, as it were. Any agreement with that? Honorable Ramatwa?
Agreed, Chairperson.
Seconder? Thank you, Honorable Kumalo. So the bill is adopted and agreed to allow then the due administrative legal process to take place, and then it will come back if there are any other amendments that needs to be done, which will be not material, which will be minor administrative grammar amendment, as it were. With that, honorable members, allow me to thank Advocate Tijana and his team, as well as the Utatuntuli, and I'm sure Tatuntuli you'll be happy, happy as ever, and as well as our state law advisor and also the DDG from the department. Thank you very much. We are not yet finished, but we are finished. Other than that, you are at liberty to excuse yourself if you wish so, and thank you very much for your patience as well. Thank you, DDG and your team. Nobabu umpemba lapha enkosi. Advocate, honorable members, now we shall deal with the minutes of the 10th, 11th, and the 12th. Okay, so we will then ask Advocate just to take us through in terms of the report on the marine oil pollution preparedness and response in cooperation with the bill, as it were. And then we'll go to the minutes. And I'm sure then we have all received the minutes and we'll take it as read when we engage on them. Advocate, I will ask you just to talk to this one and take us through.
Thank you, Chairperson and members. This is just our report on the public hearings and the engagements that the committee had on the bill, so members will see a lot of the information they have seen before when the department presented. So it's just that we had our public hearings on the 5th of September. We outline in the introduction when the bill was tabled to the committee, when we advertised from 14 July to 16 August 2023, where it was published, and when the department then also responded to those submissions. Under 2, we list all the stakeholders who made submissions and we link them to the industry or the sector that they were under. So that was the list that members saw when we considered who we're calling and when we'll be calling them. Just under 3, we indicate the only party that made their oral submissions was Sankob, and that was on the 5th of September. And then members would have seen here under 4, it is essentially that matrix that the department presented that we've added here into the report. So these public hearings reports are normally just for noting, and it is a part of the background information. When the courts perhaps have to interpret a clause of the bill, they will ask Parliament, give us some more information on what you looked at. If there is a dispute by any of the stakeholders that we did not listen to them, we can show them where the committee added their items as well, and how it was addressed and considered, Chair. So that is the public hearings report on the bill that members have just seen the A list on. Thank you, Chair.
Honourable members, is the report agreed to and endorsed as the true reflection of the road that we walk until today in terms of the public hearings, noting that it is a more of an administrative cosmetic amendment bill. So we were not obliged to go to all provinces, but also secondly to do all the 3 legs of public hearings, as it were. We dealt with one which we agreed at this committee, and we have checked as well in terms of the front table of National Assembly as also legal advice in terms of the route that we take, which we confirm that legally no one in terms of being challenged that we didn't do enough public participation, as it were. You'll recall, members, also you even raised, I was part of this committee, with why only Western Cape, and it was responded that the marine, as it were, is more of a coastal lines, but also it was advertised to everybody, not only singling out the coastal line areas or provinces, as it were, but the appetite was shown with the Western Cape coastal line, as it were. So I'm saying that so that it's very clear that we did not short-circuit the public participation processes. Hence, the report also tabled even the individuals that also had taken trouble to respond to the bill. With that, honorable members, let's get a mover and a seconder of the adoption of the report as presented. Honorable Makumalo.
Thank you, Chairperson. I move for the adoption of the report as presented.
Thank you very much. Any seconder? Honorable Ramato.
Thank you, Honorable Chairperson. I second the report. Thanks.
Thank you very much, honorable members. And